Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of these government documents coming at you. June 20th, Supreme Court opinion, Diamond Alternative Energy LLC v. the EPA. Alrighty then. Here we are addressing whether fuel producers had Article 3 standing to challenge the EPA's approval of California regulations under the Clean Air Act. So remember that California in the Clean Air Act has the ability to apply for special regulations because they were actually regulating the air and pollution and stuff like that prior to federal regulations taking place. So they have this special relationship with the Clean Air Act. So their fuel producers are basically trying to figure out if they have constitutional standing to challenge one of these acts from the EPA. Not acts, the special regulations given to California. All right, these regulations required automakers to limit greenhouse gas emissions and produce a percentage of electric vehicles, reducing demand for liquid fuels like gasoline and ethanol. The fuel producers argued that the regulations caused them monetary injury by decreasing fuel sales, with California estimating reductions exceeding $1 billion in 2020 and over $10 billion by 2030. So, to the courts. The D.C. Circuit held that the fuel producers lacked standing, citing insufficient evidence that invalidating the regulations would lead automakers to produce more gasoline-powered vehicles. The Supreme Court stepped in and reversed that decision, finding that the fuel producers satisfied standing requirements. 1. Injury in fact. The regulations reduced fuel sales, causing monetary loss. 2. Causation. The EPA's approval enabled the regulations that decreased fuel demand. And 3. Redressability. Invalidating the regulations would likely increase fuel sales based on record evidence and common sense economic principles. Evidence included California's own estimates of reduced fuel demand, statements from California's EPA affirming the regulations' impact on emissions through 2037, and automakers' concerns about competitive shifts if regulations were invalidated. The court rejected EPA and California's argument that automakers would not change production due to market trends, noting that the regulations' enforcement suggested ongoing impact. So basically, the Supreme Court is confirming that the fuel producers meet the constitutional requirements to be able to bring a challenge against the EPA for the approval of this rule. Whether that challenge is successful, that is to be seen. The case is remanded to the D.C. Circuit for further proceedings based on the guidance from the Supreme Court, so we will see. Kaimo, keep your mind open, do your own research, form your own opinion. See you on the next one.